the buyer's who's going to pay the penalty, right?
It's the buyer and the buyer's agent. A lot of
Oh my
agents aren't aware that.
goodness.
So the buyer is in the worst possible position because the buyer is the one responsible for holding the money back.
And welcome back. And today we're going to be talking about FIRPTA. And the reason why I think this is so important and why this is why I'm even doing this is because we work with a lot of different buyers and sellers in real estate transactions. And it became apparent to me that I didn't know anything about it. And maybe like you're thinking the same thing, like, hey, you're either thinking about selling your home or you're thinking about buying, or maybe you're the realtor that is like, going to be helping one of these people. And you're like, what do I need to know about this? So today I brought on an expert, Marc, and he's with Tax Solutions, and he is a CFP. And so the CFP is a certified financial planner, and Marc is actually a tax expert on FIRPTA. He actually does a lot of trainings with CLEs or CEs for the training for realtors. And so I brought him on today to help answer some of our questions about FIRPTA. And if you are a foreign seller or a buyer, this is going to be a great video. And if you're an agent, let's jump into it. How you doing, Marc?
Hey, Scotty, good afternoon. Thanks so much for having me. Happy to be here.
I was kind of confused about how this happens. And if you look at our real estate contract, you see sometimes like that it's mentioned in there, but there's not a lot to do about it. So what is this FIRPTA withholding and why is it even important? Why are we even talking about it today?
Okay, so the Texas real estate contract, the TREC 1 to 4 residential real estate contract, paragraph 20 talks about non-residents, right, or a foreign seller. And that paragraph 20 is in the contract, and it's a part of every single real estate sale that we come across. And when I teach this class, what I tell people is, hey, until we clear paragraph 20, believe it or not, you've got a transaction that involves FIRPTA, even if the seller happens to be a U.S. tax resident. And so in paragraph 20, it's a fork in the road. One of two things has to happen with paragraph 20. And usually people don't even realize that they've dealt with this, but it's just one of the standard compliance forms that the title company is going to hand out at the closing. And they say, hey, I'm a U.S. person. Here's my tax ID. This is my address. And under penalty of perjury, I'm signing this. And there's no question. And off you go. And it was a non-event. People don't even realize that they just dealt with FIRPTA at a closing. Here's where it gets interesting. When you have a seller who is not a U.S. tax resident, they say, oh, well, I can't sign that. And then people are like, oh, what do we do now? And then,
Yeah.
they hear these horror stories, about, oh, there's going to be this tax stuff and the IRS is involved and, the buyer could get caught up in this. And people have all these misconceptions, or the other end of the spectrum is, well, I've never heard of this before. This is new.
Mhm.
Well,
So
oh, go
let me
ahead.
ask you this. Like, so this happens on every real estate transaction, whether you actually know it or not, right? So as a seller or a buyer, you're signing paperwork, probably going, oh, as a seller, you're signing, hey, I'm not a foreign person, no big deal. But a lot of times the title company is preparing these documents as the agents, me and my wife we own a brokerage here in Houston, and it's like there's a lot of documents that aren't pertain to the buyer or seller. Like, so we're not necessarily worried about them, but it is in the contract. So we do need to be aware of this and knowing like that this needs to be brought to attention right away if we are going to have an issue, let alone trying to figure this out at the day of the closing, right? This is not something we should be waiting until last minute, right? Correct?
Correct. So, and I'm talking to the realtors right now. Realtors, there's some due diligence items, and I'm sure you've got a ton of them throughout the closing and, involved in the real estate sale contract. And so I'm only talking about paragraph 20. And hey, realtors, here are the things that can trip you up and cause problems for you at the closing. A couple due diligence items, listing agents are, hey, it's your job to find out if your seller's foreign. And I've had some realtors tell me, oh, well, I really don't want to ask that question. It's sort of personal and I don't want to, be that person. Like, look, it's part of the listing agreement. You go to your paragraph 21H and it's right in there and it says is or is not foreign. And so you don't want this to be a surprise at the closing table. So the question needs to be asked. Is the seller foreign or not? Because if they are, it's not the end of the world. There are just some additional compliance items that need to be dealt with. For buyers, you've got a due diligence requirement to ask the question of seller's realtor, like, hey, Is the seller foreign? Yes or no? What did they say in the listing agreement when you went over that with them? A lot of times listing agents aren't even aware of this. And then
Mm.
me informing them that, hey, this is part of your listing agreement. And I'm not trying to embarrass anybody at a closing, but I've had some of them get a little noisy with me, like, hey, this is new and I've never heard of this before. And then quietly take them aside, like, hey, it's in your listing agreement. This is something that we have to deal with. So
I
like it or not, it has to be dealt with.
Yeah, I hear you, and I think that goes to the we deal with a lot of different industries ourselves, and I did the lending side as well, and so sometimes I deal with people who seem to be. I think the 80/20 rule applies a lot, and it's like there's 20% of people out there that are killing it and they know what they're doing. The other 80% are kind of just wandering around and like no problem if no harm no foul if nothing goes wrong. But then when something happens, they're like, oh no, I didn't know anything about that. Like it's been in the contract for forever, right? Almost. And it's like you should know about this if you're practicing, real estate as an agent. And as so for the back to the buyers, like if they don't know about this, like they could be on the hook, right? If
Yep.
everything doesn't get handled correctly, it's ultimately the buyers who's going to pay the penalty, right?
It's the buyer and the buyer's agent. A lot of
Oh my
agents aren't aware that,
goodness.
oh yeah, this is a fun little surprise. So the buyer is in the worst possible position because the buyer is the one responsible for holding the money back, but the realtor for the buyer is also on the hook in two different ways. One, via the tax code, and it specifically names buyer's agent. Now their liability is a little bit limited, uh, as opposed to the buyer themselves. They've got unlimited exposure, but the buyer's agent, their exposure is the amount of their commission, right? So, if there's a FIRPTA compliance failure and the IRS wants to force the issue, yeah, the realtor could be forced to give up their commission to the IRS as a penalty. Now, that's the first bit of exposure, but the second one is this is a due diligence item, right?
Hmm.
Licensed professional has a duty to know about any legal requirements when buying or selling something, and they're the agent for the buyer. The buyer has a due diligence responsibility to that. So the buyer's agent has a due diligence responsibility to the buyer to get it right and to be aware of this. They can't say,
Hmm.
oh, I didn't know. That's not going to save them. So
Yeah.
if the buyer gets nailed, say on a $500,000 sale for up to 75K plus interest and penalties, and the poor buyer now is stuck with a $110,000 tax bill, I don't know that the buyer is going to be satisfied with the realtor only forking over their commission. The buyer is probably going to want
Yeah.
the
They're
uh, the
going,
agent to step in and pick up the slack. And
yeah, they're
so,
probably going to take them to court, right? Or something trying to,
yeah,
yeah. So
so there is a fair amount of exposure there.
yeah, so that makes this video even all the more important, right? Because you're hurting your buyer if you're not informed. You can lose your commission, you could be sued. So like not following and knowing about this could be a really big catastrophe. Um, so before we jump into some of the details, do you have an example of like this has happened to somebody?
This happens, believe it or not, quite a bit, and usually involves a misunderstanding. The money needs to be collected, and then people will think like, well, it's based on the capital gain. And so once the seller files their tax return, then title is going to give back the deposit, because there was no gain. And
Hmm.
that's not what the law says. Okay, what it says is 15% of the contract sale price goes to the government within 20 days of closing, period, end of story, full stop. Price within 20 days. It's got nothing to do with capital gain. What they're doing is they're conflating a couple of different concepts. Capital gains do come in when they file their tax return next year,
Sure.
but it's not a part of the closing. It's not a part of the withholding.
Get to the details on that, let me back up a step. So, we go to the title company there, and most of the transactions, I would say probably 90-95% of them are going to happen at a title company in
Yep.
Texas, right? Maybe they're at an attorney's office in some other states. But who's going to be like ultimately who's responsible to make sure that that 15% is being withheld? Is the title company because they're doing this the CD, the closing disclosures about where the money's going? Is it going to be
Yep.
falling to them, or who's going to be, or is the ultimately it's the buyer's responsibility to make sure that it gets paid because it's the sell, but it's actually the seller's responsibility to pay those things. So like, who do you say like who do you see making this big flub most of the time?
It's ultimately, you're right. It's the buyer's responsibility. So at the end of the day, it's the buyer who takes it on the chin when the money doesn't make it in on time. Do title companies usually do this? Yes. From a customer service standpoint, yes, it's the title company that typically is the one who's going to, well, they're going to print the check and they're going to administratively process the closing disclosure and allocate the funds and then print the check and then put it in the envelope and mail it off with tracking to the IRS, typically. Now, whose responsibility is it? It's the buyer's responsibility.
Because usually, anytime we've had closings ourselves and we've helped clients closings, they goes, okay, well, remember these documents were prepared by our attorney and they don't represent you, the buyer, or you, the seller. So they're not liability going, hey, we're watching out for you really necessarily. They're looking out for themselves and they're as a due diligence as a company, they want to make sure they're doing the right stuff. But ultimately, if something goes foul, they're not going to be the ones that are going to be, oh, well, they're going to have to come up with the money all of a sudden because they didn't do something it was on the buyer's responsibility to make sure it was done correctly. Is that what I'm hearing?
Yep. And although title companies are specifically carved out by the regulation, not responsible for FIRPTA,
Mm-hmm.
typically when it goes wrong and the FIRPTA deposit money is still sitting in the escrow account, after 20 days, typically I've got title companies reaching out and hiring me to get it fixed and try and get them out of the penalties.
Okay.
When I explain to them, well, technically you're not the one on the hook for the penalties, it's the buyer.
Yeah.
Typically title companies say, well, yeah, but we didn't mail it out and we want to make this right. Hey, that's fine. But, title somehow thinks that they're responsible, but they're not. It really is ultimately the buyer who's responsible.
Yeah, well, because they're holding money in escrow or something maybe for. So let's talk about some of the exemptions to this because this is kind of be a big scary thing. Let's talk about some of the people who we don't need to worry about it at first. So because although this could every person I think as due diligence you should be asking this question. First thing is my seller a foreign person, right? But what's the
Yep,
exemptions that I don't have to worry about it right away if they're not a foreign person, I don't have to worry about this all, right?
yep, you
Okay, so
don't.
that's the first thing. Like at the gate, like, okay, is that so I have to ask that question, I have to be it could be seen as prejudice or whatever, but like I have to ask it and I should just be asking it every time, right? No matter what.
Yeah, listing agents, it's in your listing agreement. I mean, it's right there. It's like an agreement between the seller and the listing agent.
So the
Get
listing
what?
agent should know it, but now the buyer agent comes along and they're representing the buyers, and we know like about 90% of home buyers are being represented by a real estate agent that's representing them. And so they should be asking the listing agent right away, hey, is your
Should be.
seller
Yep.
a foreign person, basically?
Yeah. Yeah. They need to inform themselves of that fact. So here's 5 ways to determine if a seller is considered a U.S. person or not. The four easy ways are U.S. birth certificate. They were born here. They might have a U.S. passport. It's the second method. Third one might be naturalization documents. They were not born in the U.S., not born a U.S. citizen, later became one. So they've got immigration documents proving up U.S. citizenship. Okay. Or the fourth one would be someone who's a permanent resident of the United States, long-term permanent resident visa. It's referred to commonly as a green card, right? So those four are super simple, right? Why are they so simple? Well, if there's a question, right, or this needs to be proven up, they can always provide a photocopy and give it to title, and they can just add it to the closing file, sign that certificate of non-foreign status, and we're done,
Hmm.
right? It's a document, standalone doc, proves up U.S. tax residency, shouldn't be any question. Okay. And that also brings up a good point. Buyers can accept a certificate of non-foreign status. It's just a document that says, hey, I'm a U.S. person. This is my tax ID number. This is my address. And I'm going to sign this under penalty of perjury and that I'm not foreign. Okay, fine. And I'm exempt from FIRPTA.
If any of those four are like, okay, we're good. They signed the document that said, we are a U.S. citizen. Is the buyer off the hook then?
Yep. Yeah.
Okay.
Once that document's been signed, I call it a certificate of non-foreign status. And in some places you'll read it's called an affidavit of non-foreign status. The terms are interchangeable. And it's added to the file and we're done. That's it. And the buyer gets a copy. The buyer is under no obligation to audit or otherwise examine that certificate, nor is the realtor, nor is title. If seller wants to commit tax fraud, that's going to be between the seller and the IRS. The only time where this gets sticky is two situations. One, if seller's not telling the truth, or two, a lot of times sellers don't know.
Yeah.
Or maybe seller thinks they're foreign because they're not from here. And so they think, well, yeah, I'm automatically foreign. And so, or maybe they have a green card, but they're not sure. Or they have a green card and they're living outside the United States. Now there's a foreign address on there. So these situations, yeah, we need to look into them a little bit. But at the end of the day, if there's no facts to the contrary that says foreign seller, then the buyer can just accept that certificate on its face. They have no duty to audit or otherwise examine it. And the seller really doesn't have any duty to prove it up either.
Okay, so let me ask you this though, because a lot of times we have buyers and sellers, they're not in the same room, they're not doing the same thing. So, like as a buyer, you might sign first before the seller signs, right? So, once again, doing your due diligence before asking this question is going to be important because you might be on an assumption that they're a U.S. citizen or a U.S. resident, and that's not going to be an issue for you. But you could close first, and then all of a sudden, then they come to sign. They don't want to sign that form saying perjury of, like under the
Yeah,
affidavit scene. So what happens with those situations?
that's going to be one for the title company. Certainly derail it or slow it down or hold it up. But title's got to deal with paragraph 20. And so the settlement agent is always going to go through paragraph 20. And this is oftentimes where it's discovered is at the closing table. So if buyer went first, yeah, this presents an issue. And for buyer's agent, y'all may have gone to the closing first, but you're not done because you're still owed some documents, some compliance docs, because the buyer's obligated to get a copy of that certificate of non-foreign status. And so once we get to paragraph 20, one of two things happens, right? It's that fork in the road. We're either going to go down the U.S. tax resident path, no withholding, we get a copy of the document, we're done, or they can't sign it. Now we've got to do withholding. We've got to hold back 15% of the contract sale price. It's one or the other. It's a fork in the road. So if you got to paragraph 20 and you're the buyer and you're going first, well, they don't have a certificate of non-foreign status waiting for you at the closing, then what I would say is looks like we're going to have to do the withholding,
Hmm.
and maybe we get the call. And
Yeah, I'm assuming that's when you got a lot of phone calls yourself. You're at the closing, and all of a sudden they're not wanting to sign that form, and then title company's calling you up and going, "Hey, can you help us out here?"
yeah, we get those quite a bit.
And that's when you direct them to help fill out the correct forms, or you do what you do, and that's when they can. So we'll include your information below and how they can reach out to you. We'll include an email or a website down below, in the links below to help contact you, Mark. Because isn't there a certain dollar amount that we don't need to worry about it too?
There could be, and that's a bit of a misconception. So a lot of realtors are under the mistaken impression that, if it's below a certain dollar amount, then FIRPTA doesn't apply. And that's not quite correct. So that's an element of the test, but there's some other things that need to come up first.
So
So,
let me clarify that, like what I said there. So if they are not a U.S. citizen or they're a foreign person,
yep,
they have to go through that. They have to determine the amount, but that's not the issue on paragraph 20 there. Paragraph 20 just says whether they are or not, right? So there's some
right.
steps that happen afterwards if they're not. But as a buyer, we need to make sure that that first question's answered, and then that's really going to go back on the buyer again to make sure the amount's holding is correct, or is it going to go back to the seller at that point?
You're referring to is if the buyer is going to occupy the property,
Hmm.
right? So Congress, is the one who makes the laws, right? And so,
Super clear.
okay, fine. So Congress does a lot of quote unquote social engineering through the tax code. What does that mean?
Hmm.
That means they try to form public policy and they incentivize certain things through the tax code. Like, hey, we want you to buy an EV, so we're going to give you a $7,000 credit, like that. So people are going to go do things that maybe they wouldn't ordinarily do
Hmm.
because they've got some incentive there. Okay, fine. So there is, again, a bit of this social engineering through the tax code in real estate transactions and known as FIRPTA. And so for sellers to only seek out owner occupant buyers, we're going to make the property their homestead. And if they get one of those, then they've got some relief on this FIRPTA withholding. So if the buyer is going to occupy the property as a primary residence for at least 6 months of each year for the next 2 years, buyer or a family member of buyer, and the buyer is willing to sign that affidavit of intent to occupy, then those two are true. The buyer is going to occupy, buyer will sign. Those two answers are true. Now we can look at the third criteria, which is contract sale price. The sale price is 300,000 even or less. FIRPTA is eliminated. They just sign that affidavit of intent to occupy, and off we can go with the rest of the closing. No more FIRPTA to deal with. We're done. This is only if it's a foreign seller. If it's a U.S. seller, we don't care about this. If the sale price is 300,000 and a dollar up to $1 million, buyer's going to occupy, or a family member buyer is going to occupy, and the buyer will sign the affidavit of intent to occupy. And it's 300,000 and a dollar up to $1 million even, we can reduce it from 15% down to 10%. Now, if it's greater than $1 million, raw land, second home, vacation home, rental, commercial use, it's always going to be 15%. Okay, so the general answer is if the seller's not a U.S. tax resident, the withholding is going to be 15% of the contract sale price, unless what? Unless buyer's going to occupy and buyer will sign an affidavit, then we can look at the sale price and maybe we can reduce it or eliminate it. Of everything I just said, the only thing they heard me say is, oh, it's less than 300,000, no FIRPTA. Not exactly.
It's kind of a social engineering that the foreign seller is going to be selling to somebody that's going to be occupying the property themselves, really. So it's like they're selling it back to somebody that's going to be living in that, in that house as their primary residence for the next 24 months, which is kind of usually longer than most things. Usually a lot of criterias are 12 months, right?
Practical use of this. Realtors, listing agents, hear me on this, okay? So first off, the buyer is never obligated to sign the affidavit of intent to occupy. Buyer can be shopping for a house in a particular school district and their children are going to go to school there for the next 6 years. And that's the whole reason they're moving to this area and they're buying that house. And the moving truck's in the driveway and they can't wait to get out of the closing and go home and go unload that truck and move into their new home. And the buyer can say the entire time through all the negotiations, oh yeah, we're going to sign that affidavit of intent to occupy. And at the last minute at the closing table, they read it one more time and they say, I don't want to sign this. And there's nothing you can do. There's nothing the seller can do, nothing title can do. There's nothing seller's agent can do. They're just stuck with it, And so, one, be nice to the buyers and deliver on everything you say you're going to do because they're giving you something of value, either reducing FIRPTA or eliminate it altogether. Or because you watch Scotty Gifford's high-speed podcast here, here's a practice tip. Here's a pro tip for you, listing agents. When you talk to your seller and you find out that seller might be foreign, in accordance with that paragraph 21H, and it's in there, is or is not foreign. If you know that your seller's foreign, then you need to have the FIRPTA discussion with them. And if you're not confident in your FIRPTA skills, then give our office a call. We can help. If FIRPTA and having it eliminated or reduced is super important to your seller, for instance, if they've got a mortgage that's up to here, this is going to put them over the edge. Now they're going to have to bring their checkbook to the closing because there's not enough equity to cover the FIRPTA. If it's really important to them, have a talk with them and say, hey, maybe we don't want to open up this listing to the universe. We just want to narrow it to only homestead owner occupants, right? And so if that's the case, we say, hey, we only want owner occupants for this property, then now you're going to have a smaller universe of people that you're putting this out to, but the ones that you do get in, they're at least going to be qualified to be able to sign that affidavit of intent to occupy. Still doesn't force them to do it, but now at least you've got buyers who are able to sign it. And it's not just the buyer has to occupy, it could be a family member of buyer. So here's an example. Let's say they're going to buy a condo that's near a university, up at A&M College Station. I see this happen all the time. The parents aren't going to go live in that condo, but the family member is going to live there for at least 6 months. And that's the criteria. Buyer or a family member of buyer, and then occupies the property for at least 6 months of each year for the next 2 years. Well, student's going to be going to school about 8-9 months a year. It's going to meet the 6-month test. You're going to university for 4 years. It's going to meet the 2-year test, right? Here's the point. If this is really important to your seller, then listing agents, what you would want to do is you'd want to make this a special provision in the real estate sale contract. talk to your broker. And my understanding is realtors can't just willy-nilly go writing special provisions. I'll leave this up to you, Scotty. You can speak to this a little better than I can.
It's
But
true.
I
Yeah, we don't
think,
practice law as realtors.
yeah, I think the general counsel for the broker would have to draft the special provision and put it in the real estate sale contract. But here's the point. Here's where I'm going with this. If this is a special provision that's drafted and put into the real estate sale contract, and this is what the buyer agrees to and puts up earnest money, it's offer, acceptance, valuable consideration. Now you've got a provision that you can hold the buyer's feet to the fire on at the
Mhm.
closing. They can't at the 11th hour say, I changed my mind. I'm not going to sign that. Right now you've got something that's enforceable. You've got an enforceable contract provision. But absent that, you're relying on the goodwill of the buyer, and they're doing this out of the kindness of their heart. And I had one where seller said, "Hey, we're going to clean out the garage and pressure wash the driveway." And on the way to the closing, buyers drove by the house, and the garage still had a bunch of garbage in it, and driveway wasn't pressure washed. And the buyer said, "No, I'm not signing." And that was that. Tough luck.
So when they didn't sign that, that meant automatically FIRPTA,
It's the whole 15%.
whole 15% of the sales price is going to be withheld from the seller. They're not getting those proceeds anymore, right? The
Yep.
title company is probably going to withhold those, and then they're going to put them in their escrow account, and they got to file the forms and send them off to the IRS, right? And so that is a lot of money that the seller's not getting that they need to go and file their taxes to get back if they're going to be getting any back, right?
Right. You bring up a good point. So FIRPTA, it's not a tax, even though the IRS refers to it a tax. Everybody calls it a tax, even in the name, or an Investment Real Property Tax Act. It's not a tax. FIRPTA is a deposit. The tax is figured out next year when the tax return is filed to report the property sale. So FIRPTA is just an advance tax payment. It's just a
Mhm.
deposit. The net of tax owed, and often there is no tax owed, they can get a refund. Does that
Yeah,
make
because
sense?
especially if they have a loss, right, too, because they could have a loss and still have to go with the holdings even. So you might have to be coming to the closing as a seller with a checkbook if you're having a 15%, off your proceeds, right? Because you still got to clear the mortgage and clear your HOA and pay your agent maybe and all those other things that are going
Yep.
to come into, you're paying title policy maybe. So like all these other things that are coming into play that you might actually have to be coming to the table if you have to pay this 15% withholding that you're not getting, right?
Yep. So here's an example that I use. Bought a
Mhm.
property for 400,000, and maybe they did a little bit of improvements. They put in 20,000 worth of some improvements. Okay, fine. And then a couple of years later, they decide, you know what, we want something else. We're going to sell this one. Okay, fine. So the property is appreciated in value. It's now selling for 500,000, and you have a buyer. Great. So bought it for 400,
Mhm.
added 20 in improvements. So now their basis is 420.
Mhm.
Plus, they've got commissions now, right? And they roughly turn out to be roughly all in after you're all is said and done with title, HOA, inspections, and a few things that I forgot about. It's going to be about another 8%. So 40K. So 400 plus 20, 420 plus 40 is 460. And they sell for 500. So they've got a basis now, an adjusted basis of 460K, selling for 500. Sounds to me like they've got about a $40,000 gain. Well, if they're a non-resident, meaning foreign, right? So non-resident, 75,000 is going to have to be withheld because that's 500,000 times 15%. 75K has to be withheld. Fine. Well, they're going to get all that money back. Here's why. On that 40,000, they're not even going to see a dollar in tax. If they're a non-resident, they probably don't have any other U.S. source income. So until they get to about $45,000 in gain, there's no tax. If
Hmm.
it's a husband and wife selling, husband and wife team selling, they're going to split this up. It's allocated to each spouse. It'll be 45 and 45. Now they're going to have to round 90,000 in gain before they see the first dollar in tax. So typically there's very little tax due unless they've got other U.S. source income. And remember, this only applies to non-residents. So a non-resident can have income in their home country, but that's not taxed here in the U.S. So we don't care about that. All we care about is the tax from U.S. sources or the income from U.S. sources. So typically, if it's a non-resident and FIRPTA applies, they're probably going to get that entire deposit back. Now, here's where they run into the problem. Let's say foreign seller, $500,000 sale, but they got a mortgage that's up to here, and the mortgage is 450.
Hmm.
Are you with me?
Yeah.
So the mortgage is 450 and they're selling for 500. Like, whew, they got 50,000 in equity. I guess that'll cover the 40K in closing costs. Huh. Yeah, that's fine. That'll cover the 40K in closing costs, except for foreign seller, right?
Yeah.
15%, 75,000. They're going to have to make up 75,000. They've only got 10 in equity. They're going to have to bring a checkbook to the closing and make up 65K.
Yeah, so that could totally kill the deal there, right? Like if the seller's got to come up with $65,000, because I know some people got some money, but sometimes they don't got that much money,
Right.
right? So
If the buyer is going to live there, right, we can reduce it to 10%.
yeah, because it's under a
So
million.
yeah, so now the withholding might only be 50,000, so now they'd have to bring 40K to the closing table. So I don't know if that's going to make it more palatable, but 40K beats 65K.
Yeah, and I guess the key point too is like you got to pay it at the closing or withheld it. You got to that's got to be withheld at the closing if they are a foreign person, and the actual taxes might not actually. This is not an actual tax that we're discussing. This is the withholding requirement. So that's the most important thing but the withholding is going to actually reduce your net proceeds as a seller. So that withholding, if you have them, then that's going to be an issue. So really, if you are the seller that's foreign person, you really want to be selling to somebody that's going to be willing to sign that affidavit saying they're going to be living there too, because that's really going to say, okay, now the title company can say, okay, our withholdings down to zero, because they're going to be living in that property essentially, right?
Right. So let's say the property selling for 300,000 even, right? And there's a mortgage for 250 against it. Well, okay, so 15% of 300 would be 45,000. Okay, well the mortgage is 250, right? And you
Yeah.
still got all your closing costs, which probably going to be around 24,000 or so. Here's the takeaway. If the buyer is going to occupy and is willing to sign that affidavit, or a family member buyer is going to occupy and the buyer will sign the affidavit and it's 300,000 or less, FIRPTA is eliminated. So even though, the payoff on the mortgage is 250, nothing needs to be withheld. So now they're going to have enough equity in the deal to pay all the closing costs, and the seller doesn't have to bring a checkbook to the closing table, and they're going to walk away with not much money, but a little bit of money.
Okay. Yeah. So like under the 300,000, the title company's gonna say, hey, you're under the $300,000 limit. So although we had to check to see because of the sales price is under 300,000, we see that our withholding is zero for this transaction in this case. It still always
You can get
matters.
to, yeah, you can get to the closing, and the buyer can say, "I'm going to live there," and they got the moving truck in the driveway. They're going to live there, and then the buyer comes in and says, "I don't like the color of your shoes. I'm not signing that," and there's nothing you can do. So if it's a listing agents, hear me on this. If it's important to your seller, then make it a special provision in the contract before the buyer signs. That's the takeaway. Otherwise, again, you're relying on the kindness and goodwill of the buyer. And
Mhm.
it's totally optional. And all about the buyer's intent at the time of closing.
Yeah.
As long as the buyer moves in, they don't have a problem. But if the buyer never moved in, the buyer never moved out of their old place, and they put renters in there a week after closing, and the IRS gets wind of it, the buyer may have a problem. Some buyers do a little bit of arm twisting and tell sellers like, hey, knock 5 grand off the sale price, and we'll sign that. And then, sellers be like, well, yeah, I'm over a barrel. And you know what? I had one, they knocked it down from 334,000 to 299,900 just to get out of FIRPTA. And that
Mm.
realtor was all proud of himself. Like, yeah, we avoided FIRPTA. I'm like, do you realize that your poor sellers would get that whole 34,000 back? Like, oh, don't tell them. Like, really?
So yeah, doesn't
Uh,
sound like a good
uh, yeah,
losing
yeah.
$34,000 at the closing. Didn't sound like a good win for the seller to me, but okay.
And they did this before anybody ever called us.
Yeah.
Had they called me ahead of time, like, hey, you know what? Just do the FERP to have the money withheld because you're going to get the money back next April. It's not the end of the world.
They've had a rental for 10 years. They might have a lot of depreciation that they need to pay back too, or whatever. But that's not your issue on the sell because they could still make money or have the FIRPTA signed withholding that it's going to be zero, but then they could still pay the taxes when it comes time to do because they're going to have those tax implications later. And that's not really the buyer side worried about anymore because we did the due diligence.
Correct. Yep, you got it. If the seller is wrong or committing tax fraud, that's between the IRS and the seller.
Yes, they are a foreign person. They said they are a foreign person, and I'm as the buyer, and I'm not going to plan on occupying the property. I'm not going to do it. Like it's going to be a rental for me. They're saying
Okay.
there's rental. I'm buying it from them. They're a foreign person. So we know FIRPTA applies, right? Because
Yep.
they're a foreign person and I'm not owner occupying it. So they're not getting around it. So we have to do withholding. So, and there's going to be 15% withholding. So now as as the buyer, I know, hey, I got to withhold this. So is there some form that I got to fill out now that I know it applies? Like there's no exemptions anymore. This is going to be withholding. The seller's they're still making a profit. So we're not worried about the closing. Closing's still going to happen. They're still getting there's some money, but like we're withholding 15%. As a buyer, what do I got to do?
Want to make sure that the 15% is collected at the closing and that the check is made out to the United States Treasury. And then that goes in with tracking postmarked not later than 20 days post closing.
And is there a form that we got to include with this?
There is, yeah, there's an IRS form. So it's a form 8288. I don't recommend the buyer try to fill that out themselves. Lots of things can go wrong with this. I don't recommend title or the realtors fill it out either. So
That's when we call you gotta get this taken care of. So help me fill out this form correctly so that I don't gotta have any tax liabilities as the buyer. Because I don't want to be sued or have the IRS calling me up saying, hey, where's my money, right?
right. So competent qualified professional is going to be the one to fill it out. That would be my recommendation.
Awesome. Yeah. So that's when they would be reaching out to you because when we know it does apply, like we've broken in the video pretty different opportunities where it didn't apply, but this is a situation where it does apply. That's when we got to get the experts involved. As a seller, saying that we do know FIRPTA applies in the same situation, and now I'm the seller now instead of the buyer. I got my 15% withheld, but I know, is there something I can do to reduce that as a seller, or no, it just doesn't matter? And I have to wait to file my taxes and see what actually comes to be.
Probably only really one thing that you can do as a seller, and
Okay.
that's limit yourself to the universe of owner occupant buyers who are willing to sign the affidavit of intent to occupy.
Okay. Because in that case, then maybe we can get the FIRPTA down to reduced or down to zero, depending on the sales price of the property. But otherwise,
I guess there's two things that they could do. They could do a 1031 exchange, or
okay.
they could do an application for a withholding certificate. Those are two ways where we could reduce the amount of FIRPTA that's being withheld. Neither one is very practical for a couple of reasons.
The way we're getting more tax people involved to help answer this question. It's not something the
Yeah,
simple. There's no simple answer for the seller if the buyer's not going to be occupying the property. There is no simple
yeah.
answer for them to reduce the withholding. It's going to be like, hey, it's going to be 15%. If you really want to try to get around it, go talk to Mark or someone else, about this situation because you're going to need 1031 exchanges. That's not easy. You got to have a third party as well too. You got to pay them money as well too.
Both definitely got their hoops and drawbacks, and both are not very practical. But once you're getting into higher dollar amounts, like say $1 million, more than a million, they start to make more sense.
Sure. You can deal with your taxes when you file them anyways and why the buyer is responsible because it seems so backwards in a lot of ways on why the buyer would be responsible for this, even though that's a seller's thing. Why am I worried about this? But it's because of, putting the onus back on the buyer so that because they know likely that the buyer is going to be there living there locally, right? Where the seller might be out of the country and leave,
Right.
right? So the buyer's still going to be sticking around because they just bought this real estate, right? So we know where they live, and we know we can contact them, right? And so we know, hey, we didn't get our money, we're going to come back to you.
And that's why we have it in the first place. Foreign people were coming to the US, they'd buy property, and they'd get amnesia. They never heard of the word tax before, even though they've got tax in the home country. All of a sudden they buy property in the US and they're tiptoeing past the graveyard, right? I don't know anything about taxes. And so they're renting it out, they're not reporting anything. Then after 5 or 10 years, it's appreciated in value. They sell, they pocket 100% of the proceeds. They leave the country and play catch me if you can. Well, if you or I did this, they know where we live, they know where we bank, they know where we work, and they know where the property is. They can just come get it.
Mm-hmm.
So that's the recourse. So that's And so ultimately they want somebody who's on the hook, and it's the one on the hook with the asset. It's the buyer.
About the social engineering that they're trying to do and why we look at this, but also from the perspective of, as the government making sure that they want to get the money that's owed to them from the seller and making it put the onus back on the buyer too.
All right, Scotty, and last couple of words here that I'll leave you all with. Closing table is never a good time to find out about FIRPTA. It's not a good time, but it's not the worst time. Okay, and here's one way where you can mitigate this. FIRPTA is not a tax, it's a deposit. Seller will see their money again. And for buyers, the IRS isn't coming after you. As long as the money's withheld and shipped off to the IRS within 20 days with tracking, FIRPTA is not going to be a problem. Now, for the realtors, if they want an explainer that they can use to have their buyers or sellers watch, just go to gotfirpta.com. So GOT, and that explains it in English, Spanish, and a couple of different other languages and different dialects. So thank you for having me, Scotty.
Awesome. I'll include that link below. Yeah, no, the pleasure's all mine. Thank you so much for coming on and doing this with us. So as always, we're here to bring you real life experience to all your real estate needs. And if you are having any FIRPTA questions or any tax questions, if you're a foreign person, reach out to Marc. His contact information will be below in the link.